reports and this giving the opinions from the judges. So.
Yeah, it's on. Then you should switch it on. Yeah. No, that's fine. That's fine.
Okay.
Yeah. Just don't go for a bathroom break with it on.
No.
Interesting.
That would be
Is the
interesting.
I'm sure that's happened.
Of course.
Right.
So is it so that Jake will start by explaining about the
Yeah. I
report
mean,
then?
first, I think Caroline will.
Caroline will. How is it?
Maybe because
I turn it off.
it may be.
Because mine is now
Or can they do that digitally, perhaps?
Mine is here, so I cannot.
So if you're
He put it. If you can put it off the mic.
Yes. So, well, that's a good point. So I'll do the introduction for Robin. You will assume walk up this way, and then I suppose welcome the panelists on as well. Yeah. Yes. Exactly. Yes. Yes. Actually, Damir or Robert, if anyone can hear, should our panelists keep the mics on now, and you will digitally mute, unmute. I think you did tell me, but hang on, I'll just double check quickly. Because I think it's you keep it on because sometimes you forget. Hot. Mics are always hot. Okay. So if you need to use the bathroom or something.
But you prefer that we keep it on?
Okay, so they should keep it off now.
Off now.
And then turn it on
now
as
it's
they
on.
go on the stage. Okay.
Robert, was it?
Damir.
Sorry. Will there be a break where we can turn this this on sort of approach.
Okay.
Also, we may try and how we're going to carry out the tables.
Okay. Okay. All right. Shall I start now, Damir? Okay. Sorry, it's very impressive you were here so early, but this is why we block a time so that we just make sure that there's always something. There's always something. But it shouldn't take the full morning, I'm sure. I mean, the discussion itself will be approximately 50 minutes, right? So, yes. And thank you, by the way, so much for coming, especially those of you flying in and back again so swiftly as well. Thank you. Oh. Okay. Problem is now I don't know when I should actually start. Because I should have a contact with Damir. I'll get my phone. Okay, Nashom? Okay. Okay, bra. Right. Good afternoon, everyone, and thank you for being with us today as we kick off SCC Arbitration Week 2025. My name is Jake Lowther, and I'm Specialist Counsel at the SCC. This year's SCC Arbitration Week is about exploring how parties can move from dispute to consensus, with a special focus on the transformative power of settlements and practical strategies for resolving business conflicts efficiently. We have gathered together global thought leaders, practitioners, and experts to discuss, among other things, the role and potential of mediation in keeping control over disputes, the experiences of diverse leaders in international arbitration, and how businesses can navigate disputes and maintain operations even in turbulent times. And also some practical tools and services offered by the SCC to support effective dispute resolution. Now, in today's session, the Settlement Shuffle, Dancing from Dispute to Consensus, our panelists will share their insights into settlement and arbitration as we officially launch the SCC's latest report on settlements in cases administered under the SCC rules. Now, according to the Swedish Arbitration Act, the subject matter of a dispute will be arbitrable where the dispute concerns matters in which the parties may reach a settlement. So settlement is therefore at the heart, the core of arbitration in Sweden. But what of the settlements themselves? In putting together this report, we hope to answer several questions. For example, is settlement more likely in domestic disputes? Which are the home jurisdictions of parties that settle the most cases? What relevance does the amount in dispute or sector, industry have for the chances of settlement? How much time does settlement actually save in arbitration? Does bifurcation or the use of partial awards accelerate settlement? At what stages or stage of the proceedings are parties most likely to reach a settlement? And does the time of year make any difference? Well, I'm very pleased to report the key findings from our report, which was co-authored with Raul J. Zivers and Joachim Raivio, and to provide data-driven insights into the who, when, and how, and also possibly some inferences as to the why of settlements in SCC arbitrations. So, to the report. Settlement in cases administered under the SCC rules. So, as mentioned, this question goes to the heart of Swedish arbitration the Swedish way. And when we're looking at the data, we reviewed the data from the years 2021 to 2023. So all cases in which a settlement was reached between 1st of January 2021 and the 31st of December 2023. So cases, therefore, included those from previous years, but were settled during this period, and not including cases that were requested or initiated during this period, but settled after the period. And this led to a pool of 460 cases in total, of which we found 74 confirmed settlements, where we could clearly see that the parties had reached a settlement agreement. So this is approximately 16%, or 1 in 6 of the cases that we saw during this period. In addition to this, often the SCC has noted that the parties may well have reached some kind of settlement, but it's difficult for us to confirm this, and therefore we've also included this number in the data as well, but have not analyzed it in connection with the rest of the report. So some of the things that we noticed. The majority of the settlements are occurring in the SCC arbitration rules, so not under the expedited rules. So approximately 76%, or rather exactly 76% of settlements of those 74 cases were settlements in the SCC arbitration rules. And when we're looking at the rates of settlement, so of those, the total numbers of cases under each respective set of rules and of those settled, well, approximately 18.5% of cases administered under the SCC arbitration rules reached a settlement during this period, whereas only 11.5% of the cases under the expedited rules reached a settlement during this period. We also noticed clearly that there were a higher rate of settlement in domestic disputes. So under the SCC considers a domestic dispute one between two Swedish parties, where there is both parties have a connection to Sweden. Where there is not, where at least one of the parties does not have a connection to Sweden, then we clearly then we count that as an international case. I'll do that again. What we could see was there was a higher rate of settlement in domestic disputes. So under the SCC's classification, a domestic dispute is one between two Swedish parties, whereas an international dispute has at least one party not residing or incorporated in Sweden. So we saw 59.5% of settlements occurring in domestic disputes in this period. And then when we're drilling down into the other jurisdictions, or all of the jurisdictions involved, we were looking at the rates of settlement, so the likelihood or how many of those cases involving parties from those jurisdictions reach a settlement. And interestingly, we saw the highest rate of settlement coming from cases involving parties from the UK, followed by Finland, Norway, Denmark, and Poland. Sweden didn't even rate in the top 5. And you can see in this graph a breakdown of a visual of some of those top jurisdictions. One of the findings was that the amount in dispute wasn't necessarily a determinative factor in, or we couldn't discern a correlation between the amount in dispute and the likelihood of the parties to settle. As you can see from this graph, there does appear to be a peak later on at the higher end of the amounts in dispute. But when this is weighted in line with the numbers of disputes, which were more often occurring at the lower end of the scale, actually it's a fairly linear development, and therefore we didn't discern any correlation between the amount in dispute and likelihood to reach settlement. However, there is a significant impact of settlement on the time taken to reach a resolution in a dispute. So, based on the average length of time in an SCC arbitration, the parties on average were able to settle in half the time of what this otherwise would take. So really a significant saving in time. And of course, for businesses, time is money. When we're drilling down into the whens of the settlements reached between the parties, we noticed that just under a third of settlements in the period were reached before the case was referred to the tribunal. So we looked at different stages also in the pre-referral stage, so from the request for arbitration to the answer, which also considered the point when the SCC would make its decision on the advance on costs to be paid. So we could see that many were, that a third were settled before referral, and then approximately, then 68% were settled after referral. And we noticed almost 50% of those after the statement of claim was submitted. And here you can see two clear stages when settlements were reached, or more likely to be reached during this period. And that is, as I said, in respect to receipt of the answer to the request for arbitration, but then interestingly also just after the final round of submissions the written submissions had taken place in the post-referral stage, and therefore before the hearing. Interestingly enough, no settlements we noted were occurring after the hearing had taken place in that period. And something that we certainly enjoyed from our perspective, and I think many of our supporters and users would also recognize the holiday effect. So we were looking at the time of year when the settlements were reached, and we noticed two clear increase and spikes. And this is coming into the Swedish midsummer period in June, and then again at the corresponding period at the end of the year, often a holiday period for many of those parties using SCC arbitration. And perhaps there are many businesses who would also prefer not to be stuck in dispute mode during the holidays. So some of the key conclusions that we've drawn from the data in the report. Settlement can offer a substantial time saving, particularly in proceedings under the SCC arbitration rules. Interestingly enough, domestic disputes and parties from the UK and the Nordics showed higher settlement rates. The holiday effect is real, and then there are two key stages when settlement most frequently occurs. That is either immediately before referral of the case to the arbitral tribunal or after the written submissions are concluded. So with that, I now would like to hand over to our eminent moderator, Robin Oldenstam, the chairperson of the SCC board and partner at Mannheimer Swartling, who will moderate the panel discussion, where we will hear on a range of perspectives from leading practitioners. Robin, the floor is yours. Okay.
Now, should we just bring everyone on stage to see how we best arrange the tables?
Absolutely.
I think that could just be a good idea. And I don't know whether I should be in the middle or...
It's a very good question.
Maybe we should begin by moving the table slightly, if that's okay with you. Is this someone's glass or is it just any glass?
That one I thought you could have.
Okay, that's fine, that's fine.
And then the others haven't been touched.
A bit more space, I think.
Okay, let's see.
Okay, then right, very good,
Okay.
very good. That's
So
fine,
we
that's fine.
switch.
No,
Okay.
I'll just
That
be
makes sense.
careful not to climb off the edge.
Maybe I'm the last one. Maybe
Anyone for a glass of water?
I had the same feeling. Oh, and there's a nice
Oh,
sun.
there's exactly.
And did you
We
want
just
me
back up a bit.
also?
Yeah, shall we?
Just to
Yeah,
avoid
you're
the
part of the
sun.
panel, I
Because now
suppose.
the sun
That'd
is
be
So
coming.
please
Yeah.
be,
That's
Now
better.
now it's
Oh, now you have
yeah.
it.
Okay, but
Or
that will...
should we come here, so it doesn't come to anyone? Or is it? Is it now?
Anymore?
Yeah. Now it's on me.
Is it on you? Okay. How do we do it?
I think it will probably also move, so... Yeah, I think that is better.
Now it's
That's
better.
good.
questions for
Good.
you afterwards about
Okay,
the
good.
survey. I was just a bit curious. I don't know, we don't need to take it now, but
Trying to make some notes when you speak.
Yes.
But maybe that would
Well, I
make it easier because we don't have to
Yeah,
be.
absolutely
If we get
curious.
one more table, so we have more space.
time.
Yeah,
It looked like an SCC arbitration goes on for 18 months
on average.
on average.
Mm.
Okay, so the
Yeah.
average is much longer than.
Yes, we usually do the median.
The median. Okay,
Mm,
right. Maybe that should be.
But because it takes into account ISDS, so it
you.
takes into account all of
Yeah,
it.
no,
Yeah.
I see, but it just someone may start thinking, oh, I thought
Then
the
I'm
SCC
thinking
arbitration was quick and that was over in about 9 months.
Median, yes.
Yeah, okay.
But I just
No.
find
It's
it interesting
only
you
Heidi.
mentioned the
It's only
holiday
Heidi.
effect.
only
Mm.
It's a longer form
But
as
have you
well.
thought about it
And I put
might
it
be
here
the
because then the
effect
sun
of
comes.
the
Then it's
annual reports?
Exactly, or
Oh,
half
yeah.
year report.
Half
Right,
year
that was my
report.
second
Yes.
question as well.
Yes.
Reporting periods. of
Yes,
what they say.
because the reporting period will
okay,
be
now it's off again.
typically December, January, or end of April, I guess.
Is it now?
Yeah. So you're there.
I'm not sure it's the
holiday.
holiday effect.
It can
It's
be a
the
bit of
report.
both, I think.
It can be
Because
the both
April,
holiday
as you say, because if we have a lot of UK parties,
we
they
have
report
a longer form,
end
we
of
have
March,
Elke,
beginning of
we have
April,
Elke,
and
which is also
that was a lower
a
point,
variation of the same
whereas it started to
Ah,
increase
is it?
again
Okay,
May,
okay,
June,
okay.
and then
Yeah.
October,
It's
November,
not used
December.
anymore.
But I think the reporting
It's
is
not a very modern name.
and
but
and
For it,
the
when I
reporting
it wa- it was-
coincides with
yeah,
the holiday
common,
It
period.
was
but
just
not-
a thought.
No,
No,
I
you
think
don't
it's
find
I
it
think
in
it's a,
pa-
a,
babies
a
it
with
will
good one.
be
Haiti.
again
I think
in
it's a good
some
one.
in 20
Good.
years when we are old.
Yes.
Is everyone good to go? Yeah. Okay. Very good. So then I'll assume that you've sort of introduced me. And I'm up.
Yes,
here now.
so that should be on there.
Yeah. Right.
And then I don't know, at the very end, do you want me to do that or you'll thank?
You can thank the audience. You mean, or
like
Both.
Pushed
both,
you guys in the
everyone.
corner, and it feels like I'm the.
let's see how.
No,
it
it's
You're-
okay.
Yeah.
You're fine.
Fine.
Good.
Absolutely. It's all good.
Okay.
And I think we need to move with the sun.
So, thank you, Jake, and good afternoon, ladies and gentlemen, and welcome to this webinar on the Settlement Shuffle. I'm joined here by a number of very prominent panelists. Well, Jake, you already know, from the Institute, of course. To his right, we've got Emma Munde, who's a partner at Wallin & Partners. She's got a very long experience in arbitration in Sweden, but interestingly, most recently, she did a year at the Stockholm District Court and the Svea Court of Appeal, and she'll give us that court perspective. To her right, we've got Elke Umbeck, who's a partner at Heuking in Hamburg. Again, a very experienced arbitration practitioners who will be able to give us the German perspective on these issues. Very much looking forward to that. And last but certainly not least, we got Heidi Merikalater from Helsinki in Finland. Heidi's also got a very long experience and in arbitration, but nowadays work mostly as an independent arbitrator and mediator, and she'll give us that perspective from Finland. So without further ado, I thought perhaps I'll start out with you, Emma. As I said, you were recently on a one-year leave doing time as a judge in the District Court of Stockholm and the Svea Court of Appeals. Now, with that experience, what would you say is the Swedish court approach to settlement?
Yeah, that's right. I did, and it was very exciting and interesting, and I learned a lot. But from the court perspective and looking at settlement, the courts take an active part or act very actively to reach settlement. And I think the reason for that is that the judges are obliged by law to raise the question of settlement and ask the parties whether they're interested in finding an amicable solution instead of going to a full hearing and judgment. So there's quite a different approach to the settlement discussion due to the fact that the judges are obliged by law to raise the question. And also the way this plays out is that usually at the preparatory meeting, which is a meeting held maybe after one or two, I would say, two submissions on each side, the court will summon the parties to a preparatory meeting where different issues will be discussed and the timetable will be set for the further procedure of the dispute. And then the judge will also raise the question of settlement. And this is a typical Swedish model, I would say, that's called the Gothenburg model. And through the Gothenburg model, it's a certain model which encourages the parties to speak more freely to the judge and also provides an opportunity for the judge to give his or her preliminary view on the case and also point out some weaknesses or strengths if they like. And it's conducted in the way that one party leaves the room and the judge speaks separately to each party at a time. And then you will have maybe a few rounds in and out the room with each party. And this, I would say it's a well-established model and generally accepted by the parties and also by the court systems. And it may seem a bit odd from an arbitrator's perspective, since I would say you, as an arbitrator, you would be very careful or even reluctant to speak with one of the parties just one-on-one without disclosing what's been said in its entirety to the counterparty. So that's one aspect from this court proceeding and how you handle the settlement discussions. And also another aspect is that the judges may go quite far during these discussions of settlement and pointing out, as I said, weaknesses of the party's case and the benefits of settling the case prior to continuing to final hearing. And if one judge has gone too far in this discussion, and there is a conflict of interest, or the question at least of conflict of interest is raised, or maybe if the judge is considered to be biased, the courts usually handle this by just reassessing the case to another judge who can march in and take over the case. So it's not, of course, conflict of interest is always a big issue, but comparing this to arbitration, if you have a similar situation, then in the worst case, I mean, you will have to restart the entire process of arbitration. So that is one or two aspects given on the court, how they handle this. And I think it's quite interesting to keep this in mind also if you are a practitioner or if you are a professional working in both these contexts, that you have a clear view on the differences, because the way disputes are managed and how the settlement discussions plays out are different. And it affects how disputes ultimately are resolved.
Very interesting. I mean, you mentioned the case management conference, if I may call it like that, when this is often raised. Is there another time where you see as a judge that the issue of settlement may be raised by the court?
Yes. If you have indications of some sort, you can raise the question whenever, and there's no time as the present. But still, just before the hearing, you will have another opportunity, usually, to discuss the settlement, because then the stakes are so high and the parties tend to be a bit nervous when it becomes obvious that they are at the point of no return, so to speak. That may be a good opportunity. And I have settled dispute even at the hearing, starting off. And I had an indication that it might be interested to discuss settlement. Let's have a few minutes. And then the case is settled. But I've never seen it after the judgment has been rendered.
So that's in line with perhaps the SCC's experience then.
Yes.
That once the hearing is over, it's rare.
Unless, yes, of course, unless it's appealed. And it's the application of appeal is allowed by the Court of Appeal. Then, of course, the discussion on settlement can also continue.
In your experience, how successful are the Swedish court in settling cases? Do they settle most cases, or is it more rare?
I don't have any statistics on that. I just have my gut feeling and experience. A lot of cases settle, but still I would say it depends on the case, and the courts are offered a number of cases. I mean, not just the disputes between commercial parties, but it can be family disputes and all sorts of disputes. And most parties, I mean, it's very rare that a party wants to litigate. It's not the aim with the discussion itself. So quite often, I would say. And the judges are very interested in finding a settlement solution because it takes the workload off them.
Very interesting. So they have their own incentive in a way for settling
In a way,
cases. Okay.
combined with the obligation of law, of course.
Very good. Let's move on and get a different perspective. Elke, I should have mentioned also, of course, that you're an esteemed member of our Arbitrators Council here at the SCC. But importantly, perhaps for this panel, you bring the German perspective. Now, what would you say would be a general approach by German arbitrators when it comes to settlement? And is there a difference perhaps between domestic German arbitrations and international ones? Please.
Thank you very much, Verban. I was very interesting listening to you, Emma, and what you explained about the Swedish court system and what parties expect in Swedish state court proceedings. So I feel that I have to shed some light on the German state court proceedings as well. We have the same obligation in our Civil Procedures Code that the judge is under the obligation to foster settlements. And probably this obligation influences also domestic arbitration in Germany. So we have the same obligation of the judge to foster settlements, but it's not written how he should do that or she. But I understand that there is a very different approach, and it's good to be here today to learn from each other and to maybe build up best practices on how we could evaluate that. So what usually happens in a German state court is quite different. A German judge would be very, very reluctant from any kind of mediation. So if the parties want to mediate a case, there will be a separate judge. That is offered. It can be done in complex disputes, but the judge who will render the judgment at the end will never mediate a case. So what he or she will do is there's a specific technique which is called sharing preliminary views. And this is sometimes adopted also in arbitration. And I know internationally that seems to be very awkward. Yeah, how could an arbitrator dare to share his view early on? That cannot be. But I think you need to know two things about that. First of all, this is always done only if the parties consent. They need to give their consent. So if it is offered at all, the arbitrators will ask the parties if they're interested into this settlement facilitation. So only if they clearly say, yes, we want to hear your preliminary view, the arbitrators will render that. That's the first thing. And the second thing is that usually those preliminary views are given in a very early stage. So after the first round of submissions or second round of submissions. And the arbitrators will emphasize, and so the judge in the state court does it, they will emphasize it is a preliminary view only, and they will continue to say that at least 10 times during the hearing. It is preliminary only. We have not seen any evidence. We have only the first round of submission. So it is just a spotlight on the current state, what they have understood so far, and it is not cut in stone. And they will, as I said, emphasize that throughout, that it's just what they understood so far. And why do they do that? What the benefit of that, you may say? Yeah, because okay, the goal is to reach a settlement, but why do we need preliminary views? So in doing that, the judge or arbitrator helps the parties to structure the dispute, to see, okay, we have these important issues at stake. There are one legal issue, but maybe not so crucial, not so relevant. We have different sets of facts. Certain facts are maybe not so relevant, others are. They will be very transparent and help the parties to structure the whole case, and also give help the parties to evaluate the risk. And that is what we think, or German practitioners are very trained in using that, to see, okay, we have a risk of over 50% that we can not ultimately not prove that, and maybe the judge don't know, the arbitrator don't know, because they don't know what the witnesses are really going to say. But you can make your own evaluation and say, well, and that can also change after the first round of submission, because when you start, you're very convinced of your case. Yeah? And then maybe after the first round of submissions, you say, oh, we have a little risk here. So maybe it is actually better to settle here at that stage than going through the whole arbitration. And that works very, very well and efficiently. And yeah, if a settlement cannot be reached, and the arbitrator or judge will be very reluctant to then have ex parte communication, or that is not allowed at all, and he will not try to convince the parties to settle. Or so he just shares the current status of the proceedings. So, and then either side can make its own assessment and see whether it might be more useful and efficient to settle. If the settlement cannot be reached, there's still a benefit, because then the council know, okay, this area has definitely to be explained more in detail, because maybe the arbitrators haven't the full understanding of what we really wanted to say on that specific issue.
On that topic, do you see a risk that once the arbiters are given their preliminary views and there's no settlement, that they can steer the parties in a certain direction where they emphasize more certain parts of the case and less others, but then ultimately the arbitrators may find something very different that decides the case, that there is this sort of, there are benefits, but there can also be some risks in that steering exercise that I guess can follow from the preliminary views?
Yeah, I think that is a fear from international practitioners, that you kind of become biased because you already shared some view, and then you are reluctant to take that back. But at least German practitioners are very used to that, and they are very transparent and open and say, well, that is what we understood right now, but happy to get your arguments. And I experienced that several times, because then I get ambitious and say, oh, well, I need to convince them more. How could they not understand my case? I need to be more convincing. And then and it happened several times that a judge or a tribunal changed its view. That can happen, and they will. They actually, if they share their preliminary view and they say, well, we haven't seen the evidence, and we have only one round of submission, we were happy to hear more arguments and cases and things. They are even, they will be very careful not to be biased, and be open to hear new arguments. And also what I think is a good benefit from all this is you will have arbitrators who read the material early on and are really focused on the dispute and not just administrating it until the very end.
Well, I can certainly subscribe to the benefits of that. So let's move on and get a yet another different perspective on things. Heidi, as I said, you are nowadays working mostly as a mediator and independent arbitrator in Helsinki, Finland. What is the Finnish perspective on this? And perhaps if you want to say something particular about mediation, that could be interesting.
Maybe I start by commenting what you said about the Swedish model and the German model. And I must say that from a Finnish perspective, I think the Swedish model sounds more familiar to me. I think there is the same kind of idea that judges have the obligation to discuss about the settlement with the parties, and they will have this around the preparatory meeting or case management conference, as you may call it. But then there is also court-assisted mediation, and that actually has increased a lot in Finland during the recent years. So the courts had put, at least some courts, a lot of effort in training judges to become mediators and to mediate cases. And you can have a separate mediator for your case, which is at the district court. But in terms of commercial disputes, quite often or mostly the commercial disputes go to arbitration. So then you would have the settlement discussions between the parties and the clients, and then you may have a private mediator. Although I'm a mediator myself and proponent for mediation, I think it's a good way of settling disputes. So unfortunately, the number of private mediations is still limited. We don't, of course, have any statistics for those, but I would say that around 15 to 20 cases, maybe commercial disputes are mediated by the private mediator. So still, it's a limited number of cases. The Finnish Bar Association has done a great job in promoting mediation, and they have mediation trainings, but still we are waiting for the big shift in the market. But still, I think I want to see the positive sides and positive signs of things. So I think there is a shift happening and increasing interest in mediation in Finland.
If you got the opportunity to work as a mediator, what would you do different then than you would do as an arbitrator when it comes to facilitating settlement?
Yeah, that's a good question. Maybe I start by saying that I think in the SCC rules as well as in the Finnish rules, there is a provision saying that the arbitrators can also facilitate settlements. But I'm not aware of many cases where this would have been used in practice. I know actually a Finnish case where a German arbitrator was facilitating a settlement and they actually reached a settlement during facilitation. But still, as an arbitrator, I would be a little bit hesitant in doing or facilitating a settlement, at least in a very promoting the settlement and trying to be very active in facilitating settlement. That even though you have this provision in different arbitration rules that the parties give a waiver to the arbitrator that you can really facilitate a settlement and you are not conflicted afterwards. But still, I think there is a risk that you cross the limits of being an arbitrator instead of a mediator. So that's at least one aspect.
Yeah. And what about time? Do you think there's a timing aspect in being able to facilitate a settlement? And what would, in your experience, be the most ideal time to try to get the parties to settle?
Yeah, that's a good question. I've had cases where the parties have only exchanged some email correspondence about the case, then cases where they have issued claim letters, maybe even initiated arbitrations. And at least based on my experience, so I think if you don't really know the other party's claims, how they would be formulated in an arbitration proceeding. So as a mediator, that's very difficult to be in a mediation proceeding if you don't really know what the claims are. And I think a lot of time in the mediation is used for formulating actually the claims and for the parties to understand what's actually the disputes. So based on these experiences, I would say that it's important that the parties and the mediator know before the mediation day what's the actual claims, what they would be in an arbitration proceeding. So then in the mediation, during the mediation day, we can concentrate on solving the dispute, not on formulating what's actually the dispute. So not to go to mediation too early. Of course, I understand the other side of the coin being that if you postpone the mediation, so of course costs will increase and so on and so forth. But from the mediator's perspective, so you need more information to initiate mediation and to have a successful mediation at least.
And when you act as an arbitrator, I understand that you would then be reluctant to be perhaps as actively trying to facilitate a settlement as I understand perhaps the German arbitrators would be, although they would ask the parties for consent before engaging on that. But would you do anything as an arbitrator to try to facilitate a settlement, and if so, what?
I think there is at least one very natural point of time where you can discuss about this settlement, and it's in the first case management conference. You can at least discuss about the procedural timetable and whether to include a mediation window in the procedural timetable. I think that's a natural way. You don't have to be very active as an arbitrator. You can just say and propose that whether there is a need or should we include a mediation window in the procedural timetable. However, I haven't seen that being used that much yet, but maybe that's a point also to me as an arbitrator that next time when I have a case management conference, so that could be at least something to be discussed.
Okay, very good. at this point, dear audience, we were supposed to hear from Marcus Axelryd, a Swedish practitioner offering the council's perspective. Unfortunately, he caught a bad cold. So for what it's worth, I'll step in, I'll change hats very briefly, just to give you a little bit of a council's perspective on this. And I can say, wearing my council's hat, I always advise parties, my party, that they should consider settlement. I mean, there are the cost and time benefits, but also because simply leaving your dispute to be resolved by a third party also means that you have no ultimate control over what the end result may be. You may assess your case, the strengths and weaknesses, but ultimately that third party may view it differently. And that risk, of course, you can avoid if you instead settle the case. So I think there are definite benefits to settlement. And as such, I'm a little bit torn as a counsel, actually. I mean, on the one hand, it's nice if the judge or arbitrator sort of brings up the topic, so I don't need to display any kind of perceived weakness by myself, saying, shouldn't we consider settlement? On the other hand, I am a little bit concerned at how it's done, but that's probably influenced also by my cultural perspective. If you're used to something, you are more comfortable with it. So for me, it is, and I do experience this sometimes in the court system, where they do offer some, sometimes some preliminary views, but not always. Especially, I don't see it much in the more complex cases. Maybe they don't really have preliminary views; it's too complicated. But I'm always concerned that no matter how many sort of caveats you're coated with, that this is all just preliminary. You have a preliminary view, but you don't only have it, you've formulated it, you put it to the parties, you may even put some arguments around it in order for the parties to understand why you formed that preliminary view. And in doing that, there is a risk, I think, of confirmation bias. I mean, the audience, of course, are well aware of that psychological effect, where once you have an initial view on something, probably to save, the effort for the brain to consider all other possibilities, the brain tends to favor arguments and evidence that speaks in favor of that initial view, and in a way devalue arguments and evidence that goes the other way. And I would always be a little bit concerned that once there is this preliminary view out in the open, that effect may kick in. And it's a psychological effect, so it's difficult even for an experienced person, a judge or an arbitrator, to avoid that. But as I said, at the same time, as counsel, I'm a little bit torn, because it's not always a bad idea to have a third party step in and say, well, shouldn't you consider settlement? For sure. Very good. Let's move on now to get a bit of perspective from the Institute. Jake, what does the SCC do to perhaps facilitate settlement?
Thank you very much, Robin, and excellent use of your two hats today. I think it's a really interesting question, because what is the role of an institution? One of the SCC's hallmarks, I'm sure you're all well aware, is the light touch approach. So from the SCC's perspective, it's very important that we provide the flexibility, the tools to the arbitrator, for example. They have discretion to conduct the proceedings as they see fit, of course, in accordance with the parties' agreement. And for us, from our perspective, this would suggest that there's the flexibility for perhaps a domestic German dispute under the SCC rules to have preliminary views or a similar mechanism. I think in particular, Heidi, your reference to mediation is something that we at the SCC are also, and of course, as hopefully you will be able to see throughout the course of the week, an emphasis on mediation. And if we can see as well that the parties are perhaps, well, in particular pre-referral, because this is when the SCC has the most, I suppose, not control, but is the administrating authority. We're the ones that are communicating and helping to push perhaps the parties to the referral or wherever they might like to go. And if we see that there is a settlement underway, we can actually raise the idea, would you like us to actually appoint a mediator, of course, for a fee, but we can facilitate that process as well. And of course, putting in some stays if the parties request this as well. This is perfectly acceptable and something we try and assist the parties, because of course, whilst all of us who really love arbitration would like to see the dispute go the whole way, that's really actually not what it's for. It's there as a tool for parties who are looking to resolve their disputes. So settlement is a very important component of the toolkit for parties and counsel, arbitrators, mediators.
What about the new tool in the toolbox, the SCC Express? Can that play a role in settlement?
Yeah, I think that's a really good good idea, actually, because the SCC Express is one of the SCC's tools that is a little bit of mediation meets a little bit of arbitration. The idea is, okay, we don't need to go the full arbitration process, and it's almost like you get a bit of a preliminary view from an arbitrator. The neutral is there to look at what has been presented in a shorter space of time and what would the likely outcome be in their view. And then once the parties have this, hopefully then they can move on. And in the ideal world where you have two parties from who are in a longer term business relationship, so something perhaps the next 5 to 10 years where they really do need to have a good cooperation, settlement is really important for them to be able to continue that relationship, move on. Perhaps it's a contractual interpretation question. What does this mean? What is my obligation? We're happy with just about everything else, but it's just a few sticking points. The neutral is there to look at what the parties present in 3 weeks for a fixed fee and then give them their assessment. It can be made contractually binding between the parties if they choose to do so. And with the neutral's consent, it can also be rendered in the form of an award, although we haven't seen that yet. The possibility exists. So it's a bit of a hybrid between the two.
And it also seems to be a little bit of a hybrid of the German sort of preliminary view. It fulfills that purpose, I guess, of giving the parties an idea of where this is likely to land if you don't settle, or at the same time it's a third party. It's not the one that will be the arbitrator, but of course it's a separate exercise. So there may be efficiency reasons why it's better to include it. I mean, there are all these sort of pros and cons. Now, you mentioned that in your survey you could see distinct times where there are more settlement. Now, if there's a settlement, how will that influence the SCC's assessment of the costs? That may interest the parties. Can we save some costs not only on counsel fees but also on the fees to the SCC and the arbitrators?
It's a very, very good question, and of course we have to consider it in the context of what is the total cost overall, and of course the fees of arbitrators and the administrative fee from the institution is something like 12% of the average cost in total. So we're not really often talking about a lot, but of course, as you infer with your question, perhaps the earlier, perhaps the lower this fee will be, but also there won't be as much fees to the council because they haven't conducted the hearing and the full arbitration either. So naturally, from the SCC's perspective, it's very important that adequate remuneration be given to the arbitrators based on how many hours perhaps have been spent on the case, how complex it was, and it should come as no surprise, the earlier the settlement is reached, the lower the fee will be. How much preparatory work has been done. If we see that there have been preliminary views made, the arbitrator, when they request the SCC to finally determine costs, because, say, the parties have reached a settlement, if the parties have agreed that preliminary reviews will be provided or some other additional settlement facilitation will be provided, we will take that into account in our decision. And it with the caveat that, of course, an arbitrator that hasn't sat in the hearing can't expect really much more probably than 50% of what the SC's original estimate of the fee would be. But it's that fine line between providing the arbitrators with the tools, ensuring the parties get the process that they've agreed on and that they expect, and providing adequate remuneration for the arbitrator, whilst also keeping those cost expectations in line with the user's expectations.
So, as a user, if I manage to reach a settlement with my counterparty and it's before the hearing, I can expect to save up to half of the costs of the SCC and the arbitrators. Would that be correct or not?
It's half of the arbitrator's fees, yes, but from the SCC's perspective, the majority of our work, as I mentioned before, is pre-referral. And even at the end of the case, we will still need to make the cost determination in accordance with the rules, and we will still need to ensure that, for example, if it's a consent award that is rendered, that it is in conformity with we have a checklist of things that we don't scrutinize awards at the SCC, but we do make sure that they're in compliance with the SCC rules and, if applicable, the basic elements of Swedish law. There are some points that need to be included for it to be a valid award. So we will do these checks, and therefore, from the SCC's perspective, it's post-referral, it's difficult to reduce the administrative fee because the amount of work is roughly similar.
While we're on that, in the older SCC rules, arbitrations had to be terminated through an award, even if there was a settlement and the parties simply withdraw their respective claims. In the rules since 2023, I believe, you can now have an order doing that or an award. In your survey, did you look at that at all, whether there was one or the other, and what would be the benefit of one over the other in your view?
Well, I think if you would like a consent, I think the vast majority are still consent awards. I think if you, particularly in the international context, if you perhaps still need to have something enforceable abroad, it's a good thing to have in the form of an award. Of course, the order doesn't have the same form requirements, and from the SCC's perspective, it's just important that we receive a document confirming that the case has been terminated and that we can continue to therefore pay out the arbitrator's fees, for example, and return the excess advance on costs paid to the parties, because especially the earlier the settlement, the more likely the higher amount that they'll probably be getting back. So whether there is a particular advantage beyond this, I'm not too sure. Perhaps it's more of a council question.
I suppose it's simpler with a simple order. If you don't want to share the actual content of the settlement, you really just want to withdraw the case from the SCC. I guess the order is the swiftest way to do that. But of course, it really depends on what the parties want to achieve with all this. But very good. We are approaching the end, but I think it would be very interesting to have, some final views. Now that you've all had the opportunity to hear different perspectives from different countries and perhaps experiences, anything you would like to sort of add towards the end? Emma, anything?
I think, to conclude, settlement is an important part of any dispute resolution. As you mentioned, Jake, the parties want to find a resolution to the dispute. And if that is through a settlement or an award, it varies, of course, but I think it's an important part of the process to discuss the issue of settlement, either through mediation or in any other way, preliminary views or what have you. And still, I think that we see many similarities between the different ways to approach this issue. But it's also very interesting to learn and to know the differences.
Very good. Elke?
Couldn't agree more. I think in the report there was a very interesting figure, the number of cases settled among the Nordic companies or the Nordic parties. And I think that shows us already that Nordic countries, and I include Germany here, are more inclined and more used to reach settlements for their disputes and not fighting that until the very, very end of it. And I think that is what we learned here today, that we have the similarity, that we have that we see the benefits in reaching a settlement, saving costs, saving time, but maybe there are different approaches how to reach that and how to facilitate that and help parties to find that.
Very good. Heidi?
Yeah, maybe to continue from the Nordic or German approach of having settlements. So I think it relates also to the fact that, Robin, you referred to the preserving the business relationships between the parties. And if we think about Nordic countries, from my side, Finland, so it's a small country. If you have business relationships internally in Finland, domestically, so most likely you will have to have some relationships with the other party in the future as well. So that's why the settlement is so important. But then maybe I just had a thought when you, the statistics from your report say that the most of the settlements are done before the referral of the case. So I think one issue, at least in the domestic cases, is the advance on costs, because maybe we don't always think about it, that it's a relatively big sum of money for smaller companies to take from their normal cash flow and operations. And that what we hear sometimes in Finland in domestic cases, that it's a big amount and then the settlements are done. So maybe that's one issue. But all in all, I think if we think about the reasons for settlements, so I think the dispute resolution mechanism, the intention for all those and aim is to have a dispute solved somehow. Whether the mechanism is called early neutral evaluation or dispute board assessment or mediation or arbitration, I think we should think about the outcome and whether there would be a good way to shift from one mechanism to another. And I think SCC is doing a good job in providing all these kind of different set of rules, and I think we need to assist the clients to resolve the dispute, whatever the means is.
Very good, very good. I thought another takeaway from the very interesting survey, of course, was that timing seemed to play a role. It was easier, it seemed, to reach a settlement after some time had gone, and there's been an exchange of submissions, and perhaps the parties know their respective strengths and weaknesses better. And that may perhaps explain, I don't know, why there are less or seem to be less settlements under the expedited rules. There's simply not enough time. At the same time, I would think, but that's my experience, that in smaller cases, which are typically those that go to the expedited rules, the amount of legal fees in proportion to the value in dispute often becomes very, very high, which means that unless you're really sure you're going to win and get all your costs back, and the other side is, able to pay those costs, you should probably think more about settlement in those cases than perhaps in the really big cases where at least the legal cost is a smaller proportion of the overall dispute. Because since we all know in settlement often the parties should bear their own costs, and that could be quite a big element. If you wait too long in a smaller dispute, it builds up. But thank you all. I think the overall conclusion is that there are many different approaches to settlement, driven very much, I think, by a little bit of a cultural difference, but they share a lot of traits at the same time, and they all come with their own pros and cons, but they probably work very well in their own settings. I guess when one needs to be a little bit cautious is when one tries to export it into another setting, which may explain the cautiousness by many in international arbitration as compared to what they may do domestically. But we all at least seem to agree that settlement is a good thing if it can be reached. Yes. So thank you all for this, and I don't know if you want to say thank you to...
Absolutely. Thank you so much, Robin, and to my co-panelists, Emma, Heidi, and Elke, and to everyone who has helped us kick off the SCC Arbitration Week 2025. We look forward to answering your questions and seeing you during the course of the week. And of course, we hope these findings can help inform your practice going forward. Thank you very much.
Very good.
Thank you so much. Well done.
Thank you.
Thank you.